Let's pause here for a moment, and I'll take some questions. So up to this point, we've talked about child care and custody. We have not talked about child support. We'll get there in a moment. But the next thing that the pleadings ask for is information about property. Now, if you have been married less than 10 years, and that's not necessarily written in stone, that's the benchmark. If you've been married less than 10 years, chances are retirement may not be an issue. Nowadays, with people's 401ks, it very well could be an issue. There might be a lot of money in a 401k. If you've been married just a year and the other person put money into that 401k during that year of marriage, it's marital money, you're entitled to it. You're entitled to part of it, in all likelihood. If you are dividing up houses or personal property, you should see an attorney. I had a lady come to me the day after she signed away her house. And she said to me, I've signed this, is this good? And I said, it's binding, and you just signed away $70,000. She said, that's okay, I just want my divorce. My husband said he wouldn't give me a divorce unless I signed this. I said, you've been living separate and apart from him for the statutory period. You were going to get your divorce anyway. You cheated yourself out of $70,000. Please consult with an attorney. It's worth that, even if an attorney charges you an initial consultation fee, it's usually a reduced rate, it's worth its weight in gold. It really and truly is. There are different types of property that are available to be assigned by the court. The court can divide a house, pension, cars. The court can even say, we're going to let the custodial parent use the property. It's called family use property. We're going to let the custodial parent use the house or use the car. And the judge could even say, ma'am, you have custody of the children, you're going to get to use the house, and sir, you have to pay money for the mortgage. It's possible that that happens. Very complex, hire an attorney. Now, in Maryland, you must have reason to get divorced. We have just passed a new rule. It used to be that you could live 1 year voluntarily and separate from your spouse. If it was not voluntary and separate, you had to live 2 years. Now Maryland has changed that law. You need only live 1 year for any reason separate and apart from your spouse, and that's why I say it's very important at the beginning of this pleading to show that you're living in different addresses. Now, that's a 1 year waiting period. There's no waiting period if your spouse committed adultery. This would really never happen in real life, but procedurally it's possible. You could walk in, catch your spouse committing adultery, run down to the courthouse, file a complaint, serve the complaint on the defendant. He or she could answer the complaint, and theoretically you could be in front of a judge that day getting a divorce. Now, it would never operate that way. The court is not that quick and speedy, but it's potentially possible. Cruelty of treatment is another reason why people get divorced, or it's a reason why people can get divorced, and there's no waiting period. It's a relatively, probably about 8 or 9 years old, reason to get divorced. I've gotten one in that period of time. My client was here at the courthouse. Her husband was in jail awaiting attempted murder charges for attempting to murder my client. That is excessively vicious conduct. I have people say to me, he calls me names, or she does mean things to me. That's not excessively vicious conduct. I had one that I thought rose to that level. My client was the wife. She was married to a very wealthy man. They were separated. Every day she would run little errands, and he would have people follow her. She would go in, park her car, go into Kmart. He would have somebody with a key get in her car and park it somewhere else. Meanwhile, he would have people go into their house, because he owned it too, and change all the clocks. She never knew what time it was. This is before cell phones. Everybody looks at their cell phone and finds out what time it is now. I thought that was excessively vicious conduct. That was cruel. Judge said no. It was his property. He could do with it as he pleased. It's a very high standard. Don't rely on that. If you're going to rely on that, seek legal counsel. Seek legal counsel. There are other reasons, and the other reason that I will talk about is desertion. I had one lady call me up and say, my husband has deserted the marriage. He has gone off to Atlantic City on the weekend with his secretary. And I said, no, well, why did he go to Atlantic City? She said, well, there was a convention there, and he is doing an IT, a computer display. And I said, so it's legitimate work? And she says, yes. And I said, is his secretary going for work purposes? Yes, she said. But I didn't want him to go. I told him not to go. He has therefore deserted the marriage. That's not the legal definition. The legal definition says it has to occur for more than 12 months. And the person, the spouse that leaves, must not be supporting the other spouse. Again, a very high standard. Don't get yourself caught up in legal terms. I went to law school for 3 years. I've been practicing for 19. This stuff is not easy. It's exceptionally hard if you're not properly trained in it. Don't fall into that trap. Let's pause for a moment and take some more questions. Oh, okay, wait. 2 final things to finish up before we complete our complaint. And the first is the property. And property could include alimony. Now, many people ask me, when is there or is there not an alimony case? Well, the first thing you need to do is realize that there is a 3-part test. First, you, the person wanting alimony, must show a need for alimony. You have to show that your income is insufficient. Then you have to show a disparity in income. You have to show that your spouse earns more than you do. Usually 30% is the benchmark. Then you have to show that your spouse has the ability to pay you. Very complex. If that is your issue, hire an attorney, please. I beg of you. Many people also, and I apologize, I meant to talk about this a little bit earlier. Many people ask me, how do I prove adultery? Adultery is a 2-pronged test, a 2-part test. Opportunity and inclination. Inclination and opportunity. Let's, for the purpose of this discussion, say that the gentleman is committing adultery. The court does not expect you to have videotape or photographic evidence of them in an adulterous act. What they do expect is for you to show that he has a girlfriend. Maybe you hire a private detective or you have friends testify or present photographs of them together. Sometimes people put in evidence the love letters. It shows that he is inclined to be affectionate with this woman. Then you have to show opportunity. I had one case one time where we had showed affection. We showed that this gentleman had a girlfriend. And then we showed that he went to her home for 4 hours during the day. And the judge asked, what was he doing that night? And I said, Your Honor, I apologize. I will be happy to answer that question, but how is it relevant? You can do the same thing during the day that you can do in the evening. And at that point, the judge nodded and said, yes, you're right. You've now proven it. It is a rebuttable presumption. You could say, my husband spent the weekend with his secretary in Atlantic City. He could say, yes, but we had separate hotel rooms, or he could say, we had the same hotel room, but it was an intense Bible study. Okay, again, it's a rebuttable presumption, and at that point, it's what the judge believes. So now, we have completed the complaint itself. At this point, there are ancillary documents that need to be filed with the complaint, but let's stop for a moment. You've completed the complaint itself. you now need to file it. You want to go to the court with the original and 2 copies. The original for the court, 1 copy for the defendant, and you want to keep a copy. You need a filing fee. You need to bring that to the court also. You give it to the court, and the court will make a summons, and 2 or 3 or 4 weeks later, you'll get it in the mail. That's that first part of the peanut butter and jelly sandwich. You've filed the complaint, and you've gotten it back. Now it must be served on the defendant. You, as the plaintiff, may not serve the defendant. You may be there when the defendant is served. You can say, that is the scum-sucking, good-for-nothing, lousy, lazy defendant. Please serve him or her. But you have to have somebody who's responsible over the age of 18. It can be your aunt, uncle, mother, brother, cousin, friend, or it can be a professional process server. The defendant is then served. If the defendant is served in Maryland, the defendant gets 30 days in which to respond to the pleadings. If the defendant is served in the United States, but in Virginia or DC or any of the other states other than Maryland, the defendant gets 60 days to respond. If the defendant is overseas, the defendant gets 90 days to respond. Now, the defendant does not have to take that period of time to respond. The defendant can answer in 2 days or 3 days or 27 days. Then the next question that I normally get is, what if that defendant doesn't bother to answer? That happens frequently. Then you, as the plaintiff, must take the affirmative duty to say to the court, the defendant had his time, but he or she, the defendant, did not answer. Now, please recall that once the defendant is served, you must file, and it's in this packet, an affidavit of service. Your process server is going to fill it out, but you should be the one to file it. Again, come with 2 copies, 1 for the court, 1 for you. Once that period of time for the defendant has expired, you then file a default. People ask me all the time, what is a default? We go to sports. If you have a baseball team and your baseball team shows up and the other baseball team does not, you win by default. You win 9-0, 1 run for each inning. Same thing with the court. You file a motion for default. The court does a couple of things. The court grants your default, sets it in for a hearing 30 days from now. The court also sends an order to the defendant. And that order says, defendant, you might have ignored those pleadings that were provided to you by the plaintiff, because you may have thought those pleadings were from the plaintiff. They were not. They included a summons. That summons is a court order requiring you, the defendant, to answer. We're going to give you another bite at the apple. We're going to give you, the defendant, 30 days to vacate the judgment. Now, the court will vacate the judgment for any reason. The defendant could say, I was twiddling my thumbs for 30 days. I just didn't feel like answering. The court will vacate that judgment. Why? Because plenty of case law says, lots of different cases, there's a rich history of case law saying, it is better to decide on the merits. This is the American judicial system. We want to hear from both sides and let the judge make the decision. That's what should be occurring. And therefore, we'll vacate that judgment if the defendant then responds. But if the defendant doesn't respond, you show up to the hearing. Oh, this is important. You have to bring a witness. The plaintiff in a divorce case is required to testify, and there must be oral corroborating evidence. You need to bring a witness who can say, yes, I, the plaintiff, have lived separate and apart from my spouse, and there's no hope that there's a reconciliation. You must do that. Now, under normal circumstances, we have that peanut butter and jelly sandwich. We have your complaint and the defendant's answer. The defendant may also even file his own complaint that you would have to answer. But in any event, we have that peanut butter and jelly sandwich. It goes to the next step. The next step here at the courthouse is a scheduling conference. For a scheduling conference, you would come right here to the Mulberry Wing. So if you're coming to a scheduling conference here at the Mulberry Wing, bring your calendar, because that's what happens. We schedule things. This is the first opportunity that the court has to determine what services you need. Maybe you need a psychological investigation of the parties or of the children. Maybe there needs to be a best interest attorney appointed for the children. The court determines this. The biggest thing that usually happens, or two of the biggest things, if there's domestic violence, they screen you in the family support services to determine if you can continue mediating or doing any of the other court services. If there's no domestic violence, then they ask, are there child care and custody concerns that remain unresolved? If that's the case, they send you to parenting classes. I really wish they wouldn't call them parenting classes. It has nothing to do with how to parent. It has everything to do with how to communicate, how to understand how a divorce affects your children. What to do, what not to do. You are required to attend 2 sessions. And they will tell you that at the scheduling conference. Many times people settle their cases at the scheduling conference, but not always. Additionally, at the scheduling conference, you get, watch out for this legal word, you get the opportunity to get pendente lite relief. Some people call it pendente lite. Pendente lite is simply fancy Latin for temporary. You have the opportunity to get temporary relief. You might need temporary relief. You might need alimony. You might need child support. On the day of the scheduling conference, you have a choice to make. You can see a judge for 15 minutes, or you can schedule a longer hearing in the future. If that is the case and you need pendente lite relief, you need to hire an attorney because you have an acute problem. You should be hiring an attorney. At the scheduling conference, you're going to set trial dates and discovery dates. Discovery is, maybe I don't have all the information I have about the finances. I can, through discovery, make the other side tell me what the pension benefits are, things of that nature. Once the trial is scheduled, rarely does the court continue it. Therefore, it is always better to hire the attorney before the scheduling conference. Because if you go to the scheduling conference, come back, and a lot of people do this. They go to the scheduling conference, it's the first contact they have with the court. They then at that point realize they can't handle this. They want to hire an attorney, but they already have trial dates, and the attorney's not available. If you're going to hire an attorney, do so early. Let's pause right here and take some questions. Let's talk briefly about the ancillary documents that are required. If you have property, you must file the joint statement of property. There are 3 sections to this, and many times lawyers don't understand this themselves. It's not tremendously difficult, but it's also not very easy. If you have been married and you accumulated an asset while you were married with marital funds, it's a jointly held asset, and that goes in section 1. If you agree with your spouse that you acquired an asset, you had a car, it was paid off before you got married, you still have that car, that goes in section 2. That's a non-marital car. If your spouse says, this piece of property is marital, and you say, no, it's not, it goes in section 3.